The next thing I wanted to tell you is just give you political updates from both the Day on the Hill and the Capitol Summit in D.C. We'll start with the Day on the Hill in Tallahassee. That was this past February 11th and 12th. It was our most successful Day on the Hill to date. We had almost 40 attendees. If I remember correctly, the first time we had a Day on the Hill for NARPM, we had 14 or 15 attendees. So we've more than doubled over the past 4 years, and it continues to grow year over year. We had great meetings with several legislators or their legislative aides, and then when the legislators are in session, they're often in committee meetings or they're on the floor taking votes, and they're not always available to meet with us. So in the situations where a legislator is not available to meet with us, we would just drop off information. We had prepared information to drop off to them. So the first one, House Bill 1293, Senate Bill 1224, application fraud. It was Representative Greco and Senator Rodriguez that sponsored this bill. This bill targets applicants who use fake identities, forged documents such as driver's licenses, bank statements, or pay stubs, or who impersonate another person to fraudulently obtain possession of a rental dwelling. Critically, this bill amends Florida Statute 83.56 to classify application fraud as an uncurable act of noncompliance. That's huge. The tenant is given zero opportunity to cure. It's also established as a third-degree felony. There are 3 specific types of fraud outlined in the bill: false identity statements, forged documents such as IDs, bank statements, or pay stubs, and impersonation. Again, this is an uncurable noncompliance. It's the same category as intentional property destruction, believe it or not. The tenant gets no chance to fix it whatsoever. You can issue them a note. If they've already taken possession of the property, you can issue them a 7-day notice to vacate, and they have zero options other than to vacate. If the landlord can terminate regardless of whether criminal proceedings have commenced or not, meaning the cops don't have to have filed charges against them for fraud for a landlord to take action to terminate a lease and get rid of them if they discover that they have engaged in fraud to get possession of the property. Now, I am happy to report that House Bill 1293 passed the House 110 to nothing on February 11th. Yeah, how about that? And if you recall earlier, I said eventually there's typically a companion version of the bill, and eventually they will get to the point where there's an identical version of the bill that both the House and the Senate agree on. And so House Bill 1293 and Senate Bill 1224 were combined and substituted. They used Senate Bill 1224, and it passed the Senate 34 to nothing on March 6th. And it has gone through all 3 readings, and it has now been ordered enrolled. And that means it has passed the last hurdle, and all that's left to do at this point is put it on the governor's desk for him to sign. So I have it on good authority that that is going to be signed into law. I don't know what the effective date will be for it, but it is typically July 1 or maybe September 1. So you can expect the application fraud bill to become law sometime this year. That's a huge, huge win for us. Really, really excited about that. Obviously, NARPM supported this bill. The next one that we talked about at Day on the Hill was House Bill 313, Senate Bill 48, accessory dwelling units. This was sponsored by Representative Nix and Senator Gates. This bill requires rather than authorizes local governments to adopt ordinances allowing accessory dwelling units in certain areas. It prohibits local governments from including certain restrictive requirements in such ordinances and removes the affidavit requirement for building permit applications. This bill also requires that this is great. This bill also requires that rented accessory dwelling units be assessed separately from homestead properties and taxed according to their use. It authorizes density bonus incentives for landlords who donate property for affordable military and family housing. It creates more rental housing inventory by mandating local governments allow accessory dwelling units. It reduces barriers to build accessory dwelling units by removing the affidavit requirement and restrictive local ordinance provisions. It expands the property management opportunities with additional rental units. And accessory dwelling units can count towards satisfying affordable housing components of local comprehensive plans. This is a bill that NARPM wholeheartedly supports. It passed the Senate 38-0 on February 4th, but it has since stalled. And so I think, unfortunately, the chances of this passing this legislative session are slim to none. But once again, this is where advocacy comes back into play, because this is something that we have been advocating for years. And this is a long game. You don't necessarily accomplish every single one of your goals in one calendar year. So this will probably get brought back up. It will be presented as a new bill next year. And since NARPM supports it in its current version, assuming no significant changes are made, we will be supporting it again next year, and we will certainly advocate on behalf of that bill. House Bill 1355, Senate Bill 1626, rent reporting to credit reporting agencies, sponsored by Representative Rayner and Senator Bracy Davis. Now, this sounds like a great bill on the face of it. Many of us who have resident benefit packages are probably already reporting positive payments to the various credit reporting agencies. This bill authorizes landlords to report a tenant's rent payment history to credit reporting agencies and allows landlords to charge a fee for providing rent reporting services. While the bill currently provides for tenant consent and opt-out provisions, NARPM is concerned that this creates new administrative burdens on property managers and may lead to mandatory reporting requirements in the future without the ability to charge a fee to offset the cost associated with that. While it was introduced this legislative session, there's been no movement on this legislation since January 15th. And so it's unlikely that it's going to gain any traction this legislative session. And just as an FYI, the legislative session actually ends on Friday, 2 days from now. So, we're coming right up against the hard deadline for any action on this stuff. I checked again this morning, and none of these bills had showed any movement at all. House Bill 107 and Senate Bill 142, termination of rental agreement by victims of domestic violence, sponsored by Representative Lopez and Senator Bracy Davis. This bill prohibits a landlord from evicting a tenant or terminating a rental agreement because the tenant or tenant's minor child is a victim of domestic violence, dating violence, sexual violence, or stalking. It authorizes the victim to terminate the rental agreement with documentation and written notice, requires landlords to change locks within a specified time period, and authorizes filing of civil action with award of damages, fees, and costs. NARPM actually does not support this bill, and that may surprise a lot of you. But the reason that we don't support it is there are concerns about the potential for abuse of these provisions and the significant liability exposure for landlords. For example, if somebody claims, hey, I'm the victim of domestic violence, I need to terminate the lease, I need you to change the locks. And what happens to the landlord if that person was lying? So in its current version, NARPM said, we think this has good bones, it's a good basic bill, but there's not enough safeguards in place for us to support this. Now, this is a great illustration of why advocacy matters so much. This bill was sponsored by Representative Lopez. So we were meeting with Representative Jose Alvarez, and we were discussing this bill that had been presented, and we were explaining to him why we had opposition to the potential passage of this bill. And Representative Jose Alvarez, I believe his district is in Kissimmee, and he has had a 20-year career in real estate. In addition to his role as a legislator, he's had a 20-plus year in real estate, and so he has a lot of experience and a lot of knowledge about the real estate industry. And as we began explaining our reasons for opposing this bill, he said, oh, absolutely, that makes total sense. I completely understand where you're coming from. And he said, I know Representative Lopez. She's a friend of mine. I'm going to go talk to her and express your concerns, because we did not have an appointment with her. She wasn't available. He said, I'm going to go talk to her. And I said, we all said, that's great. We would love to hear back from you. Hopefully something will come of it. And we left that meeting and we headed on to other meetings. And 15 minutes after we left, we got a phone call from Representative Alvarez. And he said, hey, I need you to come down to Senator Lopez or Representative Lopez's office. I'm in there with her right now. We're talking about this. Can you come meet with us? And we said, absolutely, we would be happy to. And so we went down and we met with them in their office, and he said, explain to her what your concerns are. And so we started explaining again, and she says, I got you covered. And she pulls out this sheaf of paper, and she says, I have already been in the process of drafting amendments to this bill that addresses every single one of your concerns that you've expressed. And we were like, hallelujah, this is fantastic. I mean, you can't get any faster response to advocacy efforts than 15 minutes. The funny thing is, had those amendments to the bill been included in the original bill, NARPM would have supported it from the beginning. So that's a great potential outcome. Unfortunately, this bill seems to have stalled in the current legislative session, and I don't think there's any chance of it passing. But if the amendments get added into it and it's reintroduced the next legislative session, we will wholeheartedly support and endorse this bill, because the amendments provided the appropriate guardrails that we were looking for to insulate us from liability. One of the ones that it did is it requires an actual court order before we are obligated to do anything. So that's a great liability protection for us. And there was a number of other things, but it really did address every single concern that we had. Moving on, House Bill 811 and Senate Bill 716, changing the 3-day notice requirement to a 5-day notice requirement for residential tenancies. Anybody want to take a guess on whether we support this bill? So this bill prohibits the imposition of certain fees, surcharges, and periods in rental agreements. It revises the non-payment of rent time period from 3 days to 5 days, and it prohibits landlords from imposing any fees or surcharges during that period. NARPM is concerned that extending the non-payment period and restricting fees will negatively impact property managers and property owners. I wholeheartedly agree with that. Our job's hard enough already without adding additional barriers in our ability to collect rent on behalf of our clients. Luckily, after getting introduced on January 13th, there has been zero movement on that bill whatsoever. And I have to keep coming back to the advocacy component of this, because absent advocacy, this bill may gain legs and move. So advocacy matters both on advocating in favor of something, but just as importantly, advocating against something that is bad for us. That's it for the day on the Hill. I'll move on to the Capitol Summit, which was February 17 and through 19. How many of y'all have attended the Capitol Summit? Stacy, my lovely wife. I know that because she was with me. This is our third year attending. This is a fantastic event, not only from a legislative advocacy perspective, but from an educational perspective as well. It's almost like a NARPM convention, frankly. There's lots of mastermind sessions. There was an artificial intelligence session on how it's being implemented by property managers, how it's impacting operations, concerns, and how to implement appropriate guardrails to protect our business. It was great. There was one on asset management versus property management, and that perspective matters. So many people view property management as, oh, you're just collecting rent. And there have been significant efforts in the property management profession to change the perspective of potential clients, actual clients, et cetera, so that they understand we're doing more than just collecting rent and depositing into your account every month. We are managing what possibly is your most expensive asset that you own, and it's probably for your retirement, and we are managing that asset to provide a fantastic return on investment for you. So that was a great perspective on how to accomplish that. We had the standard federal legislative update, and then we had state-specific legislative updates. I like to say Florida is a beacon of light due to its landlord-friendly status. I joke around of having the privilege of living and doing business in the free Republic of Florida. We heard horror stories about the challenges of property management in states that are hostile to landlords and housing providers. Anything from evictions taking 6 to 12 months or longer to complete. In some cases, if the if the landlord intended to raise the rent more than 5% and the tenant objected to it, at that point the landlord can't even just say, fine, I'll leave it the same. The tenant now gets to demand that the landlord pay moving cost and relocation fees. This stuff should be criminal, and yet it's actually law in some of these states. The things I heard is just nuts. One person told a story that because of the way the eviction laws work in her state, they intentionally wait until a tenant is 3 to 4 months in arrears on rent before they will file an eviction, because with current eviction guidelines being what they are in that state, it can go all the way up to the 24-hour notice, and as long as the tenant comes in and pays the rent that's due, it stops the eviction. Never mind that there are court costs, attorney's fees, late fees, non-compliance fees, all kinds of additional costs that may be a tenant responsibility under the terms of the lease. But as long as the tenant pays the base rent, they can stop the eviction all the way up to the 24-hour notice, and there's no recourse for the landlord to recoup any of those other costs. And so it seems improbable that they have this perspective, but this person was telling us about this, and they said, we literally will wait to file the eviction until the tenant is 3 to 4 months behind in rent, because that is the most likelihood that they won't be able to come up with the money at that point, and we can get possession of the property back. That's asinine. When you compare that to the free state of Florida, the free Republic of Florida, where, as long as the tenant doesn't obstruct every single effort to evict, we can get possession of the property back in 30 to 40 days. So a remarkable difference in perspective. And that comes down to advocating and making sure that you are proposing legislation and laws that are landlord friendly. A lot of these tenant advocates, they seem to think landlords are evil, and they're not. They have an investment they want to make a reasonable return on, but they also want to provide good housing for tenants. And when they put all of these laws in place that undermine the housing provider's ability to make a reasonable return, what happens? They take their ball and they go home. They sell their rental property and they go somewhere else where either they invest in something else or they invest in a state that is landlord friendly. And that means the housing supply goes down and prices go up. It has the opposite effect of what they like to say it's going to happen. There were several featured speakers at the Capitol Summit. There was a general state of the industry economic legislative environment by Brett Layson. That was a terrific presentation. Brett Layson is the Senior Director of the Federal Government Relations for Home Depot. They have the second largest PAC in the entire country, and they make good use of it. And they are a strong advocate and a strong partner for NARPM, so it was very refreshing listening to him talk. Then we had an EPA and lead paint real estate litigation presentation by Monica Gilroy, who she's an extraordinary attorney. And she has now been officially hired as NARPM's outside legal counsel. But she talked about some of the challenges that she's continuing to deal with lead paint and the EPA. And of course, I got incredibly angry over that, as you know from if you were here last year listening to me talk. But there's positive progress there. There was a presentation on ancillary fees and transparency by Kimberly Godsey, who is the Vice President of Legal and Compliance for Second Nature. Another great presentation, and let me tell you, the takeaway of that is transparency is the expected professional standard now. So if I can give you one piece of advice, it's be as transparent as you can possibly be with regard to any fee that you may have in your lease agreement, in your qualification criteria, in your applications. Don't let those be hidden. Be upfront, be transparent about it, because legislators they're on a tear finding people that aren't transparent, and they're hitting them hard. So transparency is key. Then Blake Hegeman, who is the Director of Risk Management for OMG. OMG is the management company for NARPM National. He talked about the repeal of the Chevron doctrine, and that's sort of passionate for me, but I won't bore you with that. The following issues and concerns were presented to legislative aides for constituents, congressional representatives, and senators. We've been dealing with this one for 4 years, ever since the height of COVID, and that is House Resolution 1078, the Respect State Laws and Housing Act. This has been sponsored by Barry Loudermilk from Georgia for I believe all 4 years that this bill has been presented. And sadly, he's retiring at the end of his current term. So hopefully somebody else will pick up and take this ball and run with it. But the effect of this would be to repeal the 30-day notice to vacate requirement that got enacted during COVID under the CARES Act. And as I said, we've been fighting this battle for 4 years, and sometimes I wonder, is this ever going to pass? And I honestly don't know. There are two schools of thought on this. There's the school of thought of we're starting to see positive movement in the direction we want based on the current administration, and then the other school of thought is every year that goes by, we get further and further away from when it was implemented, and it becomes the new normal. The standard operating procedure becomes the new normal. So the big House ask is to co-sponsor that bill and see if it can be pushed forward through passing legislatively. In a potentially positive development associated with this, HUD has now formally announced that they are not enforcing the 30-day notice requirement on any public housing association properties or any properties or landlords that receive direct payments from housing associations or housing authorities such as Section 8. But the 30-day notice requirement still needs to be formally repealed legislatively, and that's where advocacy matters. EPA repair, renovation, and painting rule for property managers. There's no specific bill pending right now for this, but NARPM's attorneys are actively engaged with the attorneys at the EPA, and I just was on the Government Affairs Committee meeting yesterday with Tyler Craddock, and he said those negotiations are going very, very well. He was very, very optimistic that we're going to get good results for that. The short fix to that is simply returning the 2 FAQ questions to the EPA's website that were removed by the previous administration. But longer term, we want a legislative solution for this so we have permanent insulation from the liability associated with dealing with lead paint issues. As I've said before, it can't be stressed enough that changes to this rule were made by way of withdrawal of previously published answers in an FAQ document published by the EPA. It's legally deficient to change EPA policy by removing the answers to an FAQ document. We need to deal with this legislatively. Improving the Housing Choice Voucher Program. This is specifically regarding Section 8 and reforming Section 8. They did a huge survey of NARPM members who reported a bunch of pain points associated with dealing with Section 8. An inspection process marked by inconsistencies and delays, a mandatory HUD tenancy addendum that supersedes the housing provider's lease, repetitive unit inspections, resident eligibility certificates, and other regulatory paperwork, inconsistency among different public housing authorities and how the program is administered. Fair market rents are too low in some parts of the metropolitan statistical area, and that's an area where they judge the average rent price to establish what Section 8 is going to pay for the tenants that are approved under their program. Withdrawing funds from provider escrow accounts with prior notice. That's a huge one. We heard a story from a property manager up in D.C. where she had 2 Section 8 tenants. She reported one of them to the housing authority, I believe, for drug use. And it took 2 months for the housing authority to do their investigation. At the end of 2 months, they said, yep, she's abusing drugs. They terminated her authorization to receive Section 8 housing funds. She had to move out of the house. A few months later, the housing authority pulled back the rent that they had paid the landlord during that 2 months that they were investigating, even though the landlord is the one who had reported it to HUD. You know, it's just nuts stuff like this that you hear. Another one is they had this, in fact, I believe it was this same landlord. She said when they ultimately did pull those funds back, they pulled them from the account of another tenant who was eligible to receive, and she said it had been 8 months and they still hadn't gotten that sorted out, and she was getting the runaround from HUD. So you can imagine with situations like that how some people would say, I'm not participating in HUD. But the big house ask is keep the participation in the program voluntary and reform it so it's easier for landlords to use. That was the end of all of the bills that we were talking about between Day on the Hill and the Capitol Summit. But in conclusion, I wanted to say advocacy is vital. Participation in NARPM is a great way to start advocating. Contribute to the NARPM PAC and the Advocacy Fund. That helps our lobbyist Tyler Craddock and the new member Ben Jones in their efforts to represent us all. Get to know your legislative representatives so they know to reach out to you for issues related to property management and residential housing. Visit the local offices and meet with them periodically, especially outside of the legislative session. Use your voice. If you don't get involved, you get dictated to. If you don't have a seat at the table, you might be on the menu. And lastly, one of my favorite quotes from Sam Adams, it does not take a majority to prevail, but rather an irate, tireless minority keen on setting brush fires of freedom in the minds of men. So be that tireless minority. Any questions? That's it.